invoice with the assumption you're going to have to file that complaint to enforce your remedy, because in most cases, you're not going to just send that out and then they're just going to pay you right away. Yeah, maybe you'll get your deletion, but sometimes you want more than just your deletion. So just always have that mindset. I'm going to have to file a complaint. I'm going to have to file a civil cover sheet. I'm going to have to file a whole lawsuit. I'm going to get, my case number. I'm going to put everything on the docket and move forward. Be prepared for anything the attorneys throw at you, right? Read up on the local rules and file the suit properly when you're a plaintiff. Keep up with deadlines for responses. You don't want to miss deadlines. But the thing also too, like I said, I'll put case law about this. As a pro se litigant, there's case laws, constitutional laws that backs the fact that you don't necessarily have to do everything right. You can mess up as a pro se litigant. You're not held to the same standard as attorneys. And I'm pretty sure most attorneys know this, but they're going to call you out sometimes saying like, oh, you didn't do the process right, this, that, and the third. But I'm going to put in the Facebook group one of these case laws that'll help y'all actually go against that. But like I said, I don't want to present too much information until we're actually in it, because I don't want to overwhelm y'all. But as y'all getting y'all cases, the attorneys are questioning y'all authority. It'll just look in a Facebook group. It'll be there. Hit me up personally. I'll send it to you. File a motion to strike when they respond with a motion to dismiss your initial claim, right? So get in the habit. You have to file a motion to strike their response. You can't just type up a response and be like, oh, they didn't respond to my affidavit, right? So while that might be true, you got to understand that you're working in their venue, a court of law. So you have to file these motions. So you would title it motion to strike. You would title your affidavit motion to strike. This is a motion to strike, their motion to dismiss. Address all their points and, stand on your ground. Use your tools I mentioned earlier. And then, you'll be that much closer to getting your default judgment. Like I said earlier, when you're the plaintiff, when they use Rule 12B, the defense motion, 12B number 6, which says that you don't have a claim that relief can be granted, you want to reiterate that your claim where relief can be granted is in your affidavit they failed to adequately respond to. They're basically saying that you're stupid when they're saying that Rule 12B number 6, they don't have a relief where claim can be granted, after we specifically sent them an affidavit with exhibits, with an invoice, right? So obviously we have provable violations where relief can be granted. So they're basically just testing you when they send that to you. Attorneys are going to test you. That's the main thing I need y'all to understand. Attorneys are going to test you. They're going to test you, but it's up for you to not fall victim to what their tests are. Stand your ground on what you're saying. Like I said, they will try and test you. 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 So you just got to be disciplined. You got to stick with what you're saying and just be consistent. All right, let's say you're the defendant. You might get sued by a debt collector, the attorney representing them. You might get sued by CRA, maybe, or anybody, right? So you want to respond on time to the summons with the debt validation and or motion to dismiss their claim, right? So keep that in mind. If you're getting sued, definitely respond. You don't want to miss out on your deadline. Definitely reread the FDCPA 15 USC 1692. Reread the sections in there. 1692E3, an attorney can't communicate with you, so they've already messed up by doing that. You want to read your federal rules of evidence. So 601, 602, corporations cannot sue you. If they're attempting to sue you, a debt collector, that's a corporation. Rule 601, you're not even competent to testify. Stand your ground on everything you're saying. Federal rules of civil procedure, study that too. And then study your Rule 12 defense motions. I already gave y'all the Rule 12B number 6. They don't have relief that could be granted. Rule 601, you're a corporation. Rule 602, you're an attorney. I'm questioning your authority. If you can't testify under the penalty of perjury that you have firsthand knowledge, this case needs to be thrown out. So, stand on your ground. Read up on the local rules and do not miss deadlines. Do not miss deadlines. Do not miss deadlines. Do not miss deadlines. Like I said, respond with defense motion Rule 12B number 6 against the attorney for lack of firsthand knowledge. Rule 602 and against the corporation for not being competent. Rule 601. It's these basic things you just got to remember, but really stand on what you're saying. Stand on what you're saying. Do not miss the deadlines. I said earlier too, you can use Rule 12B number 5 if you were not properly served per the local rules. If you weren't properly served, right? So this is why you want to be familiar with the local rules. If you look up the local rules, it says this, this, and this. It has 3 steps of how to serve, how you're supposed to be served, but you only received 2 of the steps. 12B number 5, you weren't served properly. So, it needs to be dismissed. Respond with 15 U.S.C. 1692 E3. The attorney cannot communicate with you. They're communicating with you, saying that, we're attempting to collect this debt from you. There's going to be a judgment against you. They're going to say what they can to try and scare you. Send that motion over to them. Stand your ground on what you're saying. They will try and test you. Attorneys will try and test you. They scare people every day. These corporations scare people every day. Don't be shook by them. Just stand your ground on your paperwork. Or your affidavit. Affidavits are powerful. I think we're aware of that. So you always want to send your affidavit with exhibits